It's time for the Financial Crisis Talk Center with Ken Gross and David Einstandig from Thav Gross.
Credit card debt is number one. I view it as financial cancer.
40% of your gross income is going to just pay the debt service. You got no chance of getting out.
I would give up my credit score to get rid of debt.
Here's your host, Ken Gross.
So if I've got an employment contract and it has a covenant not to complete or a non-solicitation clause, do I have to worry about that, or can I say, no big deal, I'm free to do, I can earn my living, I can do whatever I want to do, I don't have to worry about that, I can go work wherever I want to, I don't have to worry about that, do I? Good morning, David Einstandig.
Good morning, Ken. It's always a pleasure to see you.
It is?
Yeah.
You feel that way every single day?
Most of the days, yeah. Why?
Monday through Friday?
Yeah,
Saturdays?
correct.
Sunday? Do you want to see me in the morning on Sunday too? Don't you need a rest?
No, Saturday's a day of rest.
Oh, this is rest.
This is rest. What's going on?
We're talking about covenants not to compete. Did you figure that out from the opening of the show?
Restrictive covenants.
Restrictive covenants.
They're not enforceable, are they?
Yeah, I don't know. What do you think?
It's like everything else in life.
If you talk to Fred the bartender, they're not enforceable.
Well, it
I
depends
was
if
sitting
Fred,
at
if
the
Fred
bar.
signed one or not.
I was sitting at the bar the other day, and the couple next to me are talking, and she's saying, I've got this employment agreement. There's this covenant not to compete in it. I don't know if I can take this position. And Fred said to her, you don't have to worry about that. You're entitled to earn a living. I know that. You can just go ahead and sign the contract. Don't worry about that. It's no big deal. It's nothing. Don't worry about it.
How many agreements that have covenants in the last 25 years have you reviewed approximately? Ballpark.
That's
A couple hundred,
just about
maybe?
every single employment agreement I've reviewed would have some form of a restrictive covenant.
Several hundred, right?
More probably.
Okay.
Over the
Let's
last 30 years.
Let's say 1,000.
Well, 1,000 would be 30 a year, wouldn't it? On 30 years. So I don't think 30 a year. Probably less than 1,000.
Okay.
Probably more like 700.
Okay. Out of those 700, how many had to do with bartenders?
None. None. I've never reviewed an employment contract for a bartender. Have you?
Right. No.
No. So what are you saying? Fred doesn't know what he's talking about?
I'm saying is Fred should stick to bartending.
You know, I just thought of something. I'm giving the wrong name. I usually talk about Jerry the bartender.
There's only one
Jerry
bartender in southeastern Michigan?
No, but Jerry the bartender's been the bartender I've always picked on the show all these years, and now I've switched his name to Fred.
It would be so uncommon for you to just switch right in the middle.
All right, well, the word of the day today is covenant, as in restrictive covenants, and I want to do kind of a little bit different show with you and I. I don't want to talk about real financial crisis issues. You know, we're moving the show to Law and Reality, which is going to be a broader spectrum of legal issues and dealing with the realities of life. So I thought, as a way of getting the audience and the radio and the TV audience ready for how we're going to deal with Law and Reality, I thought I'd sample it today with a little bit on covenants not to compete. It comes up all the time. Now, first of all, what is a covenant not to compete? This is going to be question and answer. I'm going to ask the questions. You're going to be stuck giving the answers because Brian, where is Brian?
Who?
Brian is not here today.
I don't know.
And Jenny had an emergency, even though she was planning to be here, couldn't make it. But so it's just you and me, Dave.
But it's a good question, Ken.
Did you notice I'm saying Dave, not David? Do you want to know why? You want the history on that?
Tell me why.
Well, while we were waiting,
Tell me, Kenny.
While we were waiting for the show to begin today, and I was getting a little agitated because you're always cutting it close to the hour. Joe and Dave and I were talking. Dave back there, our producer, Dave, and said, David gets a little bit annoyed with you when you call him Dave. So I said, well, then we'll work Dave into the show. It's going to be the Ken and Dave show today.
That's correct, Kenny.
Okay.
He doesn't like Kenny, does he?
What goes around comes around, baby. I understand that.
You dislike Kenny much more than I care about Dave.
You're probably correct. Okay, what is a covenant as in a covenant not to compete?
It's actually an excellent question because when you use the word covenants or covenants not to compete, depending on the context, it could be an array of things. And in the legal world, we actually use a term that we call restrictive covenants, with the term restrictive meaning basically you agree by contract that you're not going to do something. Now, if you think of that as the big umbrella, that's a restrictive covenant. Then when you start looking at the different types of restrictive covenants, they could be all over the gamut.
Well, let's subcategorize a couple. Two come to mind. One is a non-compete, and the other one would be a non-solicitation. So what's a non-compete provision?
Typically, when we're dealing with a non-compete provision, that's when a person, typically either an employee or an independent contractor, agrees with an employer or somebody else that for a certain period of time they will not compete with that line of business. Now, it gets a little bit more intricate.
Well, don't get intricate yet.
Right.
Just give me the other one.
Basically, for example, it says for 2 years after our relationship ends, after our employment relationship ends, I will not compete with your business, and then it all goes down to how you define your business.
I will not directly or indirectly compete with any engage in the same business, similar, and so on and so forth. What's a non-solicitation as opposed to a non-compete?
A non-solicitation typically involves that for a certain period of time, you agree that you will not solicit, means you will not seek business from, and typically it would be existing customers or clients that are defined in the agreement. So these are two totally different things. One is I'm going to stay out of the business altogether for a certain period of time. And the other one is I can go into the business. I can actually go right next door. But I agree that these customers or prospects, people that I learned of during my relationship, are going to be hands off from me going after them. But you raise a good point. What if the customer comes to me?
So that's where, because non-solicitation, by definition, if you don't get more express about it, says I won't solicit or seek the job. It doesn't mean I won't accept. You can also have non-solicitation language that says non-acceptance, which says I will not accept or provide any service to any of the former customers of my employer or the business to cover that issue.
And that's when you're getting into not only a non-solicitation provision, but also a non-compete provision. And most of the time, we do see those together, not separate.
Well, we're coming up to the break, but what I want to kind of focus on is there's two circumstances that you see these restrictive covenants. One is in the employment contract context, and the other is in the context of the sale of a business. When we come back from the break, I want to kind of review the history of restrictive covenants from an antitrust standpoint and then talk about it in the business world. We'll be back.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross. Our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Fav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Fav Gross today, 888-235-HELP.
Are you struggling to pay your mortgage? Afraid of foreclosure and the financial mess it can cause? Time is not on your side. Call Alan Stalter, the short sale specialist. For years, Alan has been helping distressed homeowners navigate through the short sale process. His experience will get you out of your home without the credit score damage that follows foreclosure. If you want a fresh start, you need to call Alan Stalter, the short sale specialist, 248-854-3829 or MetroDetroitShortSale.com.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Fav Gross specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
Worth Ave Gross. Our firm will solve your problem.
Going from hourly to salary seemed like a good career move, but now you're working 60 hours a week instead of 40, and you aren't getting paid any of that extra time. You're stuck, right? Wrong. You can be on salary and still be entitled to overtime. If you've been wrongly denied such pay, you may be entitled to that and more. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
All right, we're talking about covenants not to compete in an employment contract and also in the context of sale of a business. So what I was leading up to at the break is I said it's not just in employment. Suppose I'm selling my business. In that case, if I'm selling my business and I have and I'm the owner of the business and I'm selling it to you and you're buying it, you don't want to buy the business and then find out that I'm competing against you the next day to steal all the customers that I just sold to you, correct?
Absolutely, Ken. And then it begs the question, getting back to Jerry the bartender, well, these covenants, they can't be enforceable. I'm entitled to earn a living. I'm a U.S. citizen. I pay my taxes. I can go out there and I can talk to anyone I want.
And there is an antitrust component to that. There's, it's basically prohibited for restraint of trade in the United States, in our capitalist economy, is frowned upon. So restraint of trade, there's a whole bunch of antitrust legislation. So there's an issue with covenants not to compete
Absolutely.
as to whether they're valid or not. What's the basic history on that?
Well, the basic history is that Jerry the bartender for many, many years was right. And when we talk about the law...
I thought we're talking about Fred the bartender today.
That's his cousin.
Okay, go ahead.
Okay. It's like Daryl and his other brother. Daryl.
Got it.
All right. Here's the 10-second history 101.
Wait! I just got breaking news.
What's that?
I heard from Joe. Brian is in Guam. That's where we've located Brian. He's in Guam.
Know what they call that?
No.
A good day.
Okay.
All right. So historically, or what we call at common law.
Not good day for Guam.
Okay, not a good day for Guam.
All right.
Covenants not to compete infringed upon an individual's constitutional right to contract and to have free trade, and they were not enforceable. And you were entitled as a citizen of Michigan for sure, because it's state by state as well as the federal law, but you were entitled to go out and earn a living and not have to worry about these covenants. Then what happened was, in about the mid-'80s, statute in Michigan came about, in the employment context in essence. And what the statute basically did is it permits covenants with some caveat. And it permits covenants so long as two things. They are reasonable, and number two, they do what's called, they serve a legitimate business purpose. So those are two key things. You have to have both. If you only have one, it's not going to be an enforceable covenant.
Now that's in the employment context. In the context of selling a business, they've always been enforceable.
Historically,
as a necessary component, but on an employment context, they were frowned upon for a while in Michigan because it does prohibit and limit the employee's ability to earn a living after he leaves, but there is a necessary component from the employer's standpoint.
Yeah, and as a result of this mid-'80s legislative change, the vast majority of covenants, whether it's a sale of a business or an employment or independent contractor context, they do get analyzed almost identically with a little bit more deference on the sale of a business because they recognize that if you're selling out your business, the buyer has to have some protections. But in essence, it boils down to, no matter what, in any circumstances, they need to be reasonable. And there's a ton of case law in Michigan as well as throughout the entire country that analyzes what it means to be reasonable as well as what is a legitimate business interest. So there's a lot of law on it, and it's fact-specific. That's the bottom line.
So if you have a covenant and it is deemed to be reasonable, what's the damage remedy? What can the employer in the context of an employment contract or the buyer in the context of a purchase of a business and gets a covenant not to compete, what is their remedy if there's a violation of this covenant not to compete?
First, I'm going to take the easy example, which is the sale of a business. If there's a sale of a business and then there's a violation, and let's say the president or the CEO of the former business that sold out to you you negotiated, let's say, a 3-year or a 4-year covenant not to compete, and the next day they turn around and they start soliciting all the same customers. They want to sell them the same product, and they say, they're not enforceable. The remedy is that you must act quickly if you want any chance of getting what's called injunctive relief.
Or what is injunctive relief?
Injunctive relief.
Quickly, not long.
Injunctive relief is when you ask a judge or an arbitrator, and let's just say we're in court now with a judge, you ask the judge to prohibit somebody from doing something or require somebody to do something.
So you can actually stop them from being able to do what they were doing to violate the covenant with the powers of contempt of court if they fail to abide by the judge's order.
Correct. Think of it as two doors. One is money. I can always go after and ask for money, but that takes a year, year and a half, 2 years. If my business is decimated, that's bad.
Well, what's the standard in order to get that injunctive relief?
The standard to get injunctive relief, because injunctive relief is only supposed to be utilized for special or what they call extraordinary circumstances. There's, in essence, a 4-factor test, but it boils down to is you have to pretty much show that it's that there's a great likelihood that you're going to prevail in the merits of the case, and you have to show, which is the other one that really boils down to, is there's no adequate remedy at law, or it's so difficult. And what that means is it's so hard to quantify in dollars what your damages would be.
Because you're going to lose all of your business, and you can't assess how much that business is worth, or it's difficult, and it could be so great. Therefore, you need the injunctive relief.
And we refer to this as intangibles like goodwill. My goodwill is going to be damaged. I don't know how I could calculate it. So that's what gets argued in front of the judge immediately. If you sit and wait too long, there's a less likelihood of getting injunctive relief.
All right, so the question comes to this. First of all, you have the covenant not to compete. You're going to have to look, is it enforceable? The court's going to look at the time and the distance and the reason for the covenant, what interests of the employer or the seller of the buyer of the business have to be protected, and then they're going to make an assessment. Now I want to switch over more into the employment context, because those are the ones that we get all the questions all the time, because it comes up in a lot of different scenarios. Suppose I'm just trying to get my first job, and I'm coming out, and the employer gives me an employment contract, and I read the contract, and I see the covenant not to compete in there. I have to make a decision. Should I sign this agreement and be bound by this covenant not to compete? That's one question. The next situation that comes up oftentimes is someone switching jobs. And when they're switching jobs, they have an existing covenant, and the concern is, can they take the new job, or will they be sued for violating the old covenant? And then the new employer is all worried about that. So when we come back from the break, we're gonna really explore the employment context of covenants not to compete, and that'll probably take us through the end of the show. We'll be back after the break.
Tax problems are major problems. Don't let the IRS levy your wages and seize your assets. There is a solution.
Worth Ave Gross, our firm will solve your problem.
If you're behind on your taxes and owe money to the IRS, call Thav Gross.
We've been solving tax problems for 32 years. We stop wage levies, resolve unfiled returns, and obtain the best possible settlements.
Call Thav Gross today, 888-235-HELP.
You like your job. What you don't like is the way your boss has been treating you. He's making comments about how you look instead of your work, and he's been touching you inappropriately. If you complain, is he allowed to fire you? Absolutely not. Unwelcome sexual comments, advances, and contact are illegal in the workplace. Make him pay. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Is the debt piling up? Struggling to get by?
It's all about preserving future income. Bankruptcy is one option. When it's right, it's the least costly, most effective way to save your home, eliminate a second mortgage, and wipe out credit card debt. But you need to address the problem now.
We help people with bankruptcy. Call the experts.
Worth Ave Gross, our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
Every family has the family meeting, and we all know what that means. Dad's got dementia. what are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call, because I can do it for you.
Carrying too much debt? Resolve your debt. Call Thav Gross.
You don't need to be broke, and you don't need to hit rock bottom. If you have income and you're struggling with debt, dump it. Think about the next 10 or 20 years. If you do what the banks tell you, you'll have nothing to retire with. There is a solution.
Don't waste your future. Call Thav Gross. We're experts at eliminating credit card debt. 888-235-HELP. That's 888-235-HELP.
Do you know what time it is? You know what time it is?
Yes, I do.
What time is it?
Time for announcements.
Very good. Very good. I like that. I didn't even cue you in on that. All right, let's do announcements very, very quickly. First of all, we've already said we're switching over to Law and Reality from Financial Crisis Talk Center. That's going to be first week in August. As of now, that's the planned cutoff date. We have a Reg X special report. Reg X is the new law, federal law, that governs the process of foreclosure. It provides a lot of opportunity, if you act promptly, to leverage yourself into a loan modification. It's not well known out there. You're not seeing a lot of discussion of it among the commentators because it hasn't really filtered out and the lenders don't really want to talk about it. But it is a valuable tool. I've written a report on it. It's a 10-page free report. If you want a copy of it, go to regxhomesaver.com. You can download the free report. You don't have to. We don't make it download. We actually email it to you once you enter your information in there, because you don't want to You never want to download things that you don't know where the link's coming from because of all the bad stuff that's out there. So you got to be careful about that. regxhomesaver.com, or just go to the Financial Crisis Talk Center website. There's a link on it right there to get to it. The Financial Crisis Analyzer is still up and operational and available for use. It's free. You enter your information. It tells you what your basic options are in terms of if it's bankruptcy, a smart play or no, debt resolution, would you be typically eligible for a loan modification or not. Put 3 years of work into putting that together. It's free. All your data is secure, not released to anybody. I want to thank our sponsors, Gold Star Law, Samasco Law, Elite REO Services, Alan Stalter, Trips Auto Shop and Collision Center in Jackson, U.S. Staffing in Jackson and Lansing, and Cardiology Associates of Michigan, which is coming on board. We've got 2 events coming up. July 16th at our office in Bingham Farms. We're repeating the Protecting Your Life's Work seminar that focuses on elder law, estate planning, dealing with the issue if you or your spouse or your parents are headed into the nursing home situation. How do you protect the assets that they have, make them eligible for either veterans benefits if you're a wartime vet, and or Medicaid planning, because you've got a 5-year look-back rule and you've got a lot of things that you have to deal with in order to preserve those assets. And if you do the right steps, you can preserve them. The wrong steps, the state ends up getting all of your money.
What time is that seminar?
Good point. It's at 6:30 to 8 p.m. If you want to sign up for that one, go to cannotaffordtolose.com. That's cannot afford to lose, as you cannot afford to lose your money.com. And then on Wednesday, July 23rd, we have a seminar, Your Future Without Debt. That's from 7 to 8:30 at our offices in Bingham Farms. It's focusing on how to preserve future income for you and your family. The whole essence of what our philosophy is you've got to plan for your future and have something to retire with. Beyond saving the money, the easiest way to start saving is if you have excessive debt, get rid of it. We have strategies to get rid of debt. Sometimes it involves bankruptcy. Sometimes it doesn't. Sometimes it's a loan mod. Sometimes it's letting the house go to foreclosure. The key is you got to trim the debt off before you can start saving the money. And if you don't get there and start saving the money, you end up 75 years old living on Social Security and you can hardly afford your apartment. Typically you can't. So you need to do things about it. To sign up for that seminar, which is on Wednesday, July 23rd, go to financialcrisistalkcenter.com or thavgross.com, and there's links there to sign up. Now back to restrictive covenants in the employment context. All right, so you're already employed. Can the employer require? I'm going to give you a couple questions. You already have your job. You don't have a covenant not to compete. I come to you and I say, Dave, here's this document, sign it. And you read it and you see it says you're agreeing to now 3 years into your employment, you're agreeing to a restrictive covenant. Do you have to sign it? Are you required to sign it?
You have to have two assumptions. One, assuming you are an at-will employee.
You have to sign it. I want a yes or no question.
You don't have to do anything.
Correct. You don't have to sign it, but what might happen?
I
could fire you
if you are an at-will employee, the law says that the employer can require you to sign a covenant, and if you don't, if you're an at-will employee and you're not under a contract otherwise for a specific term, then you can be terminated. And there is no protected right not to have a covenant.
So let's back up. So the reason, the rationale behind it is if you're an at-will employee, which means the employer can terminate you at any time and you can quit at any time. Neither party are compelled to continue employment, as opposed to being a for-cause employee, which means you could only be terminated if for an act for cause. So if you're an at-will employee, in essence, when the employer is giving you that restrictive covenant to sign, he's saying if you want to continue your employment, that's the consideration for continuing, you need to sign. So they're saying there's consideration.
Right.
Now, this would be a whole nother fun topic, but we're not going to have time for it. It would be consideration, offer, and acceptance, which I'm going to save for a later show. But they could enforce it against you in that circumstance. Now, you're offered a new position, and you read the agreement, and you see there's a 2-year covenant not to compete and a non-solicitation provision. What should you do? We only have about 2 minutes. I've got a thought, but do you have a quick one?
First thing you should do is not sign it until you discuss with somebody that knows what they're doing as to what the ramifications are. I can't tell you how many times people have called me up and said, let me know how this is, and they send me a document and they've already signed the covenant.
Yeah, which is the worst thing to do. Here's where you're at on that, because we're running short of time. You have to look at making that decision. You have to say to yourself, okay, is this a field of work that I've devoted my career to, and if I end up leaving this job, am I going to be able to relocate to find suitable work, or am I going to have a big problem? And then how badly do you need this job versus another job?
And you can carve out. If you brought 30, 40, 50% of your customers to that employer, you can try to carve out the book of business you already had.
Biggest word is negotiate at that point. Don't just sign it. There's room to negotiate. We can reduce the size of the covenant. You could have it excluded if the employer terminates you. We're going to need to do more on covenants not to compete in a later show because we just scratched the surface on it today. The important thing is don't just sign. You need to have representation and be smart about it. Thanks for listening to this segment of the Financial Crisis Talk Center.